Hi, I am Eric Maxfield. I am an attorney and I practice in Boulder County. I also specifically practice landlord-tenant law, and every Friday I appear at Boulder County Court as a contract attorney for Bridge to Justice, where I assist tenants. And so that's why I'm here today to talk with you about going to court on an eviction. So the first thing I'd like to start with is a disclaimer, and that is that this is only information and not legal advice. An attorney should be consulted in any legal matter, and also note that the law may change at any time. And I'm going to use the term landlord and tenant in the singular, but multiple parties could be named in notices and pleadings, both on the landlord side and the tenant side. And I'm specifically also speaking today about landlord and tenant law in Boulder County. I will be referencing Colorado state law, but mostly as far as the way things play out, the traditions and conventions of the process. My reference is to Boulder County Court. And so what is fundamentally happening when it comes to an eviction in Boulder County? Well, a Boulder County eviction is process, and so that's in contrast with self-help. So our laws don't permit a landlord to self-help, and I would put that in quotations, meaning to escort a tenant off the property. Instead, if they want to evict a tenant, they must avail themselves of court process. So they have to file a proper notice and a proper complaint, and a proper summons has to be issued. It has to be served properly, and that's a subject of a different video that's also part of our series. And additionally, part of that process, fundamental fairness requires that in addition for a tenant having a notice and a complaint, that they be able to appear and contest the eviction. So they can file an answer, and they can, in that answer, describe why they are entitled to possession of the property. So ultimately, I just wanted to highlight that because it's a very important fundamental part of our system, that this eviction process is not about self-help. It is about process, and there are many complicated requirements of that, both for landlords and tenants. The process was made for landlords to have the benefit of a quick process to obtain possession, and it was made for protective for tenants to have a process to ensure fairness, notice, and an opportunity to contest. So most of the law that applies when you are facing an eviction, if you are facing an eviction, is state law, and that's under what we call our Title 13, Article 40, Section 101, and subsequent sections of the law. There are other laws that apply, such as warranty of habitability, among others, but the main law that applies is that Title 13. When you receive a notice and ultimately when you receive a summons that requires your presence in court because the landlord has filed a complaint, it will provide you with a date and a time and a place. So that will be typically at the Boulder County Courthouse, either in Boulder or in Longmont, at a specific time on a specific date. You must appear at that place and time. If you do not, it is highly likely that the judge will issue default judgment to the landlord. Case closed. You lose. And a sheriff may enforce that, what's called a writ for possession on the judgment, possibly within 10 days. Now, it depends on the circumstance. A judgment might issue on that day, which is typically a Friday or a Monday, but it will be typically 10 days before a sheriff may enforce that writ. So once there's a judgment, as I said, there's no self-help, then the sheriff can enforce that and can escort a tenant from the property. But as a tenant, you do not need to let that happen if you have a defense. So the defense is something that's called an answer, and that's what I'm going to get to in just a moment. So first, back to the concept of just appearing. So it's very important to appear at court. It's important to appear a few minutes ahead of time. You will need to allow time for probably parking, to go through security, to find the proper courtroom, and to settle into that place, and to make the clerk or the judge let them know that you're present. And what must happen at a return, what I'll call a return date, that's what the summons is telling you to come to, is one of two things. Either you will file an answer, or you will come to an agreement with the landlord and agree to what's called a stipulation that you put in front of the court and ask the court to make an order of the court. And typically, if both parties do put a stipulation in front of the judge will accept that and make it an order of the court. If neither of those things happen, that's when the court will generally issue a default judgment against the tenant, giving possession to the landlord, again, that could be enforced by the sheriff no sooner than 10 days from that judgment. So one thing that I want you to know about the confidentiality of the proceedings is it is open court. There is a docket that's posted outside the courtroom in paper form, and despite that, the eviction filing by the landlord is what's called suppressed. So it is not a public record. It's not available to any public or private search firm that calls through information about landlords or tenants, about evictions. It is suppressed, meaning it's closed to the public. That's very important because it protects your right because there hasn't been a judgment at that point. And until and unless there is a judgment, the matter will typically remain suppressed. And if you ever have a question about it remaining suppressed in the process, you should ask. And that is a very important right of the tenant to have it suppressed in certain circumstances. And in some circumstances, the judge will have discretion to suppress it. The tenant will typically want that suppressed and should ask the court, ask the judge to see if it will be suppressed. So one thing that is can be confusing about appearing at court for a return on an answer date for eviction is who is present and what are they all doing, because the courtroom is typically full of people and they all have different roles, but most people don't have name tags or badges or obvious roles except for the judge, who does have a nameplate out and a robe so we can tell who that is. Typically present are mediators from the city or county, and it could be Boulder, it could be Longmont, it could be others, and they are free to landlords and tenants who wish to have a skilled neutral, someone who can help resolve a dispute. And that can happen right there at the courtroom. Out in the halls, there are some private rooms, but mostly even just in the hallway, where the landlord and tenant can get together and express their positions and perhaps compromise and reach a resolution. And that's where that resolution would be a stipulation that's presented to the court to make an order of the court. And that would avoid typically having to file an answer as far as the tenant's concerned. There are also often city or county staff present who are knowledgeable about emergency rental assistance. So if the issue is non-payment of rent or any payment that is owed, it can be good to come to court simply to find out what your options are there if you haven't done that already. Now, it doesn't mean that there will be assistance, but there could be. And that could, in some circumstances, resolve the whole case, cause it to be dismissed, and remain suppressed so it's never public. That's a great benefit to a tenant. Also on the topic of non-payment of rent, when the landlord is alleging that, there is an opportunity for the tenant to what's called cure that, what's typically called by the landlord a lease violation of non-payment. If the tenant pays all that is owed, not all that is owed in a notice or demand, but all that it is owed up until the date of court, to the penny, if that is paid, then the landlord must dismiss or the court must dismiss the case. Now, some landlords will not accept payment, and if they don't, a tenant does have the option to file the funds with the court in the court's registry. And in that event, again, the court will dismiss the case. There are some details that I won't go into today about what type of payment must be made, but that's a very critical right of the tenant to cure an alleged non-payment violation of a lease. And remember, if the case is dismissed, then it should remain suppressed, and you as a tenant should ask the court to make sure that that's happening. That means no one in the public will have access to that information. There will not be a judgment of eviction on your record in that situation. When you come to court, if you meet with the landlord through a mediator, if you talk to an attorney who's there, like myself, to assist tenants, and you don't reach a resolution with the landlord, you must file an answer, or the judge will give judgment of eviction to the landlord. That will be between you and an attorney, if there's one available to you, as to who files that. So if the attorney can file it, that's beneficial to you, and they will work with you to get squared away on the facts and how the law applies to those facts to make all of your appropriate defenses, affirmative defenses, and counterclaims that are necessary to be in a pleading, in an answer. And it will have to be typically filed by 5 p.m. on the date of your return date. If it's not, again, default will enter against you. If you are filing an answer on your own, there are forms available at the courthouse. And there's a fee to file an answer, but you can ask the clerk for a motion to waive filing fees. That's a motion that you file with the court providing some information about your income that says, I have low enough income, court, that it's hard for me to pay the filing fees. Please waive any fees and let me just file my answer without a fee. And very typically, the court will grant that motion. In your answer, you cannot just say, I don't like this. What you must tell the court in writing are the reasons why you were entitled to keep possession of the property. And typically, if a judge, when I say court, I typically am meaning judge, a judge may ask you, what is your answer? What is it going to assert? Because if you just say, well, I really don't want to leave, that's not a legal defense, and the judge will probably just give judgment to the landlord in that event. But if you say, well, they allege that I didn't pay, but I did pay, or if you say, they allege that I violated the lease in some other way, like I had a barking dog, and it bothered people, but I don't have a dog. So that's something that the court would view as an answer that justifies you keeping possession, and you could file that as an answer with the court. The court will then set the matter for a trial, and it will do that very quickly. The law says that it should be set within 7 to 10 days, so it'll typically be set within a week, from that Friday maybe to the next Friday, or sometimes to the early days of the following week. You can tell the court, if you wish, that you waive that filing, that trial deadline, and that you're okay if it gets set farther out. And most tenants would be okay with that. I also want to highlight that there are a number of possible defenses to an eviction that an answer should contain. And the challenging thing about filing an answer is that you really need to include all of your possible answers, all of your legitimate, real answers. And so that could be that you can test the facts that the complaint is based upon. It could mean that you contest lack of proper notice. Could mean you contest lack of proper service. Could mean you say, well, they accepted somewhat rent from me, so they waive their notice of non-payment. It could mean that you file that you say, I paid the rent, so their statement of non-payment is contrary to the current facts. It could be that you allege that their pleading, their complaint, is deficient in some way. It could be that the landlord is discriminating against you because of the source of your income, and that's against the law. That's a defense. It could be that there are federal or state laws that protect you against discrimination, so that if you believe you are being discriminated against and have proof of that through exhibits, like records or documents or testimony of witnesses, then you could assert that there's a violation of the federal or state fair housing law. Also, domestic violence is a very important thing to pay attention to in the landlord-tenant matter. A landlord cannot evict a tenant who is the victim of domestic violence if the basis for the eviction is that conduct of the perpetrator of the violence. That's a protection for the victim of the domestic violence, and courts take that very seriously. A very complex area of the law that provides some protections is a warranty of habitability that I mentioned at the outset of this video. The warranty of habitability provides that a landlord is required to provide basic things like heat or water or a roof that's functioning in a home, and if they don't, it could be that rent is cut back or abated or lessened. And so that could play a role in a defense to eviction, but it is a complicated set of laws, and there are very demanding requirements of the tenant as well as the landlord. So that requires a tenant to do a lot of homework right away if there's any kind of deficiency like that in the tenancy, as soon as they learn about it. I won't go into depth today about what occurs at a trial on an eviction matter. It's called a possession hearing because it's about physical possession of the property. But I will note that at a trial, a judge will typically be setting that for only 1 to 2 hours, and that's for both sides to put on their side of the case. And that amount of time is extraordinarily limited and requires both sides, and the tenant included, to be very efficient and organized and focused in what information they're putting in front of the court. And the information in front of the court typically is in 2 categories. It's witnesses, so testimony under oath, and exhibits, so records that you can bring in that you can show are authentic and related to your defense. And it will help the court, both the witness testimony and the exhibits, understand why your defense should mean that you are entitled to possession. If you prevail at that trial on that date, the court will dismiss the case. The case should remain suppressed and will be closed. If you do not prevail, you may have an ability to appeal. That is also complex and a bit challenging, and you will need to file a notice of appeal, and the judgment could be carried out unless you ask for and the court agrees to stay or put on hold the order. So what I mean by that is, if you go to trial on an eviction as a tenant and you lose, you are very likely to be evicted with a writ issuing, judgment issuing, and then no sooner than 10 days from that date, the sheriff could escort you from that property unless you file an appeal to the district court. pay those fees, and unless you have that order of the county court judge for eviction stayed, meaning put on hold. That is something that is very challenging, including for an attorney to accomplish because of a number of legal requirements, but it is possible, and so I would recommend that you seek the advice of an attorney immediately if you go to trial, and if you have judgment against you, and if you believe you have an appeal. What the court is issuing if you lose at trial, or if you negotiate a move out, in some of these circumstances is not only judgment for eviction or for possession, but a writ of restitution, or a writ that allows, it's a piece of paper that tells the sheriff whose property it is. Otherwise, people will be perhaps calling the sheriff and saying, so-and-so is trespassing on my property. The writ helps the sheriff understand who has a legitimate legal right to be there. And so once that writ is issued, the sheriff will have a date on it, and the sheriff can enforce that no sooner than 10 days from its issuance. Now, in practical terms, it may be that the sheriff is not available to escort someone from the property on 10 days after the issuance, and it may be a number of days after that before they can be available. But that's very difficult to predict from the tenant side, and often from the landlord side as well. So if there is a writ issued, it's really important to be out of the premises by that deadline. One thing I'd like to highlight is that when you come to court, because you're facing an eviction, it's very important to get there a little bit early and to look around and to ask around and see if there are attorneys available to assist you in your defense. Attorneys are often at the courthouse who are present through Bridge to Justice as attorneys from that organization or contract attorneys, and will provide you with information and advice, and if possible, and they will tell you if it's possible, they may be able to even file an answer on your behalf and help you with a trial. Most likely, most often, the attorney will be able to help you negotiate a resolution with the landlord or the landlord's attorney. That will typically involve compromise on both sides, but it is typically also something that both sides, landlord and tenant, decide they can live with. And ultimately, the attorney can help ensure that that process that is due to you through the courts to ensure fundamental fairness through notice and an opportunity to be heard is effectuated not only to the landlord's benefit, but to your benefit as a tenant.